Hello, thank you, and welcome. This is Ryan Gertis with the Recon Group. I am going to be going over the vacant land and lot purchase contract today. So let's get started. This first page is going to be an intention to buyer page. Think of it as a table of contents. Whenever you see any bold print, probably pretty important to pay attention to it to at least get an idea. Some of this will be applicable to you, sometimes it will not. So throughout the contract, you'll hear me talk about when it would be applicable, but ultimately you are going to want to speak with your wealth manager to determine what is and what is not. Without further ado, let's get into it. Page 1. All right. Line 1, section 1A, you're going to have the buyer's information and the seller's information. Section 1B is where you'll have the property address, the zoning. It'll be whatever the current zoning is, not what the future zoning could be. So that's very important. Assessor's numbers, that is going to be the assessor number on the plat map that the county or the state has appointed to the land. Then you have the city, county, and zip code. Legal description oftentimes will be identified from the title company or on a completely separate document, because sometimes those can be pretty lengthy. Purchase price will be on line 9. Earnest money will be on line 10. We'll go over a little bit more about earnest money a little bit later on, but ultimately earnest money is designed to keep everyone honest. It is money that is put up front by the buyer, generally held by the escrow company, in order to move things along and keep people honest. Incidental improvements. So in the event that there's an improvement on a vacant piece of land, maybe like a shed or like a parking slab, it is simply saying that those things will be conveyed in as-is condition. If there are other fixtures or personal property on the land, then it must be identified in section 1E. Maybe it could be some fence posts, maybe it could be some signage, any of those types of items, but they are generally transferred with a non-monetary value. Close of escrow will be here on line 27. Generally speaking, we're looking at a minimum of 45 days to close a vacant land deal. Because of the due diligence periods, which we will go over a little bit later, you can anticipate a minimum of 45 days or longer. All right, moving on to page 2, possession. If there's a gated community or something like that, then when you close escrow, then that is when the gate clickers or keys or whatever is necessary in order to access the property, that's when it will be handed over. Ultimately, we're looking for the words funded and recorded. When you hear those two magic words, that means that it's official and that the land has transferred from Mr. Seller or Mrs. Seller over to Mr. and Mrs. Buyer. Addenda incorporated, additional clause, that'll be a completely different discussion. Buyer contingency, that would be in the event if the buyer needs to sell another piece of real estate in order to qualify or buy this piece of real estate, then a buyer contingency would be involved. If there's a well on the property, which is very common for county islands, then this would be required if there was a well on the property. If there's an HOA, this box would be checked. Occasionally, sellers will carry back the loan over to a buyer. That would be a loan assumption or a seller financing document, depending on how that financing is postured. On-site wastewater treatment facility, you might know this better as a septic tank. That would be for this box here. A short sale, we don't see too many of those here in the 2020s, but they do still exist. That is when a property is being sold short for what the seller owes on it. Vacant land lot purchase contract addendum regarding subdivided or unsubdivided land. Again, that would be a completely different topic to discuss, so please discuss with your wealth manager. If there is an all-cash sale, the proof of funds and or letter of credit will be required to be submitted within 5 days of contract acceptance. Type of financing, there's conventional FHA, VA, USDA, assumption, seller carryback. Anymore, the FHA and VA land loans and USDA land loans, they're not very common. So more often than not, you're going to see conventional, assumption, carryback, or down here on line 44, if this was a cash sale, you'd check that box and there would be cash there. So financing, this is if going back to that contingency, that buyer contingency, that's where this would tie in here, is if there was or any other contingency requirements for the buyer to obtain financing, that's when that would dictate which box is checked here. Financing commitment and contingency period. Ultimately, here's the deal. The buyer needs to do their best to move forward with the financing, if there is financing, as fast as they possibly can. They need to get everything over to the title company with sufficient enough time in order to close the transaction. That means that loan documents are there, insurance, taxes, or any other documents are there in order to satisfy the transfer of the property. Pre-qualification, this is a form that must be submitted with all financed offers. Loan status update. You as a buyer are responsible for staying in touch with your lender and keeping the seller updated on the process and the progress of your loan throughout the life of the transaction. Loan costs. The default of this contract are going to be that the buyer is responsible for all of their own loan costs, and the seller will be responsible for their own costs. VA loan costs. There are some VA loans out there that have requirements for the seller to pay for those specific fees. Please get in touch with your wealth manager to get the complete breakdown of that, as well as your lender. Changes. In the event that you want to make any changes as a buyer to your loan program or to your financing, you may do so long as it doesn't affect any part of this transaction or this contract. So if you wanted to go from a conventional loan over to cash, so long as it closes at the same amount of time or sooner, and it doesn't affect the nets that the seller receives, you do not need permission in order to make those changes. However, if it does change anything, then you will need to get permission from the seller. So this can sometimes be a little bit of a gray area, but moral of the story is if you do want to make any changes, please just let everyone know, and more often than not, it works out. If an appraisal is required, the buyer or seller can pay for it. That'll be checked here on either one of these boxes. Partial release. This means if there's any partial release of financing, it must be described in the additional terms and conditions or a separate addendum. Page 3, subordination. In the event that there's maybe a construction loan, or if there's a carryback or any type of creative financing, sometimes we'll see subordination loans, meaning that they'll go in second position, allowing for a different loan to go in first position, for example, a construction loan. Escrow Company. The Escrow Company is going to be the one actually handling all funds, and they will also be the company that transfers the title from seller over to buyer. That information will be detailed here in this section. Title investing. As a buyer, you need to discuss that with the title company. As a seller, you will have already discussed that with the title company, and they will be the ones helping out with that. Title commitment and title insurance. Both buyer and seller are required to get title insurance on the buy and sale of their property to ensure that no one comes knocking at their door in the future saying that ultimately that they're owed money or anything like that. So it is actually a requirement here in the state of Arizona. Additional instructions say that there's an HOA or a seller wants to pay off a loan on the land that they are selling, then the title company or escrow company will be the ones reaching out to that lender or to that HOA to get payoff information or transfer information and covenants, conditions, and restrictions from the HOA to disclose over to the buyer. Prorations, expenses, and adjustments. Buyer owns the day. The moment that the buyer closes on the property, they are responsible for all taxes, rents, or deposits from that day forward, and the seller is responsible up until that day. So if there's any taxes, rents, or deposits, those must be accounted for from the escrow title company and passed over to the new owner. Moving forward, release of earnest money. In the most ideal situation, the earnest money will be released upon the close of escrow back over to the buyer. If there was a breach of contract and the contract cancels, then this contract allows the title company to release earnest money pursuant to the contract. Assessment liens. More often than not, you're going to see this box checked right here, paid in full by seller. That means that the seller would be responsible for paying off their mortgage that they have on the property prior to close of escrow. IRS and FERPTA reporting. That means that Uncle Sam or whatever governing body from whatever country that the seller may reside or buyer may reside means that they will be informed of this and that there are other requirements if you're one of our friends outside of the country. Agricultural Foreign Investment Disclosure Act. That would be something that you'd want to have a discussion with your real estate wealth manager to see if this applies. Tax deferred exchange. If you are an investor and you are buying or selling real estate, you are going to want to make sure that you have this identified as a 1031 with your qualifying intermediary prior to close. Vacant land lot seller property disclosure statement. Seller, you have 5 days in order to fill out that document and send it over to the buyer to disclose anything and everything that you know about the property. If there are any other disclosures that disclosure statement does not ask or does not prompt you for, it is still up to you to make sure to get that information over to the buyer. If there's a road maintenance agreement, you must disclose that and send over a copy of that agreement over to the buyer within 5 days as well. If there is a well on the property, whether it's a shared well or a private well, all that information needs to be sent over to the buyer. If there's a tenant that is occupying the land, then any and all information in regards to that tenant must be sent over to the new buyer as well. Environmental disclosure. If you have any underground storage tanks or anything that has an adverse effect to the environment, or anything that has an effect to the environment must be disclosed over to the buyer and or disposed of prior to close. Affidavit of Disclosure. This one can be tricky sometimes. Essentially, this really only applies to county islands with subdivided 5 or fewer lots. This really is a situation where you are going to need to have a discussion with title company and with your wealth manager to see whether or not this applies, because there's a lot of questions to be asked in order to determine whether or not this applies. HOA, if your land is in an HOA or planned community, then you will need to check this box. If not, you'll check this box. Changes during escrow. If after the due diligence period and after the disclosure period has passed, let's say a big storm comes through and washes out a bunch of very mature trees and carves a bunch of ditches in the land that really affects the property adversely, then that needs to be disclosed. Seller warranties. This is basically saying, seller, whatever you put in writing must be so. Just like the buyer, whatever you put in writing must be so. It must be true as well. Any warranties that survive closing are warranties that were essentially omitted or not disclosed or hidden from the buyer. So seller, if you have an underground storage tank that you installed with a bunch of hazardous material and you did not disclose it over to the buyer and the buyer finds it after they close, you will still be responsible for that underground storage tank, as an example. Due diligence. You might better recognize this as the inspection period. For vacant land, we have 30-day inspection periods because they can sometimes take a little bit longer. There's percolation tests, there's different soils tests, there's tests that you might want to perform for wells. There might be some utility research that you need to do, usage research you want to do, entitlement research you want to do. There's a lot of different things that you're going to want to do that you may have not thought of, and these can take a little bit longer than they might take on maybe a residential purchase contract for a home. So these can take a little bit longer. Buyer, it's up to you to determine whether or not the square footage is accurate. Buyer, it's up to you to determine whether or not there is flood insurance required on the property, or if there is any flood dangers. It is up to you to do any inspections on that. Buyer, it is up to you to determine whether or not the insurability of the property is sufficient. Buyer, it is up to you to determine whether or not there's a sewer or wastewater treatment system on the property. However, the Arizona Department of Environmental Quality does dictate that, seller, you are responsible for making sure that a septic tank is certified and in good working condition and pumped prior to transferring over to the buyer. Okay. Site soil evaluation, that will be for the buyer to do what's called a percolation test. So generally speaking, that will be on the buyer's dime in order to get that done. Buyer, if you decide that you are wanting to buy this property in order to subdivide it or to do anything different than what it is already being used for, then it is completely up to you to make sure that you do all of your research prior to the end of due diligence period. Roads, if there's any maintenance that you want to do, or any updating or anything like that, buyer, it is up to you to make sure you have that done during your due diligence period. Surveys, if you intend to build on a piece of vacant land, chances are you are going to want to get some type of a survey. More often than not, we see a boundary survey and a survey plat map showing just the corners. If you have any intent to do any subdividing or anything that's a little bit beyond what the current zoning dictates, you're probably going to want to get something that's a little bit more in depth from a licensed surveyor. But this is the section that you'll be determining all that information. Well water rights. Buyer, it is up to you to make sure that the well water is sufficient for your intent. Buyer acknowledgement. Again, these are all in bold print, so please read through this. Buyer acknowledgement. This is essentially saying that you recognize that we as wealth managers are helping you identify property on the real estate side, as far as helping you get through the contract and advising you on those elements, but the actual land itself, surveys, inspections, so on and so forth, that is not within our qualifications. It is totally up to you to hire people that you feel are adequate for your purposes. All right, moving forward, due diligence period notice upon that 30 days, not any days, not one day later. You are going to want to submit a response over to the seller reflecting your findings. If there's any items on that are adverse or that you have concerns about, make sure you ask all those questions prior to that 30 days. Ultimately, you'll have three options. Door number one, accept the land as is and seller don't touch it. Door number two, we've decided that from what we found, we do not like it. At that point, you can cancel it, get your earnest money back. However, any funds that you've submitted for surveys, appraisals, inspections, entitlements, so on and so forth, that money you will not get back. That is the cost of doing business. But door number three, that is essentially a second wave of negotiations, if you will. Maybe there needs to be better roadway conditions, or maybe the well needs some work or whatever. At that point, you would renegotiate with the seller on that. Verbal discussions will not extend time periods. As a matter of fact, verbal discussions don't matter at all when it comes to any type of real estate purchase contract. Inspections, seller, you need to make the property accessible to the buyer and their inspectors in order to perform their inspections and due diligence. Remedies, cure period. This dictates that if either party breaches the contract, the other party must give the breaching party 3 days in order to correct the breach. If the breach is not corrected, at that point, the party in which that was not breaching can cancel the contract. alternative dispute resolution, exclusions from ADR. Paraphrasing all this, if there is a dispute or there is a breach, the idea is that everyone's going to sit down and talk about it, see if we can't work this thing out verbally, and then move forward in writing. If that doesn't work, then we will get brokers involved. If that doesn't work, we will get title company involved. If that still doesn't work at that time, you might decide that you want to seek legal representation. You must know that if you decide to hire an attorney, whether you are the buyer or the seller, if you do not win, then you will be not only paying your attorney fees, you will be paying the other party's attorney fees, as well as any other damages that are come about. If there are any other additional terms and conditions, they will be notated here. Risk of loss. So let's go back to that flood that came through and washed out the lot earlier. If it does 10% of damage to the property or more, then either party can cancel the contract, and then we will have to shake hands as friends and walk away, because sometimes just acts of nature happen. Permission, we are going to let everyone know that it is under contract. Arizona law means that this is a legally binding contract. Time is of the essence means that if you say you're going to do something, do it right away. Compensation, more often than not, the compensation for the seller, the title company, the insurance company, the brokers, so on and so forth, will be monetary compensation. The seller's compensation, the buyer's compensation will be the real estate itself. Copies and counterparts means that the contract will not be several copies, it will all be one body. Days are all going to be referenced in calendar days. The contract does not care about weekends, holidays, or birthdays or anything like that. Calculating time periods, you cannot close on a weekend or a federal holiday, or there are some acts of business that can't be conducted except for during business days. So please account for that when you're putting together your timelines and scheduling. Subsequent offers, the seller can still accept backup offers. Cancellations must be done so in writing, and they must be pursuant to the contract itself. Notice means that everything must be done so in writing. The earnest money is, going back to page 1, is the money that is going to be held at the escrow company more often than not. Generally speaking, we usually do a personal check, but you can do certified funds, wire, so on and so forth. There is also an option for a broker's trust account, but that is less and less common anymore. Again, bunch of bold print here. Your real estate wealth manager is not responsible for the square footage of the lots, the lot lines, boundaries, or anything that has to do with the property itself. Our job is to essentially facilitate the transaction. In terms of acceptance, this is the area where the buyer will give a seller a time to respond to the offer. If that time is expired, then that essentially means that the contract has been withdrawn at that time. However, more often than not, it can be resurrected by a counteroffer or an addendum. All right, and the last page will be all the broker information, buyer information, and the other broker's information, and the seller's information. And that is it. Thank you so much for listening. Hopefully this has been helpful for you to navigate the vacant land purchase contract. If you have any further questions, please reach out to your real estate wealth manager at the Recon Group. We thank you so much and have a great day.